I was going to read his bio, but you can go to the website and do that. Justice Kelly replaced Daniel Prosser in 2016. He was appointed by Governor Walker. He happened to be sitting right over there about a month before you took your place, as I recall, so we got a chance to meet him. And then I had the great pleasure about a year and a half ago to actually sit in his office for about an hour and a half, 2 hours. And I found out how little I know. So, wonderful man. What a delightful conversation we had together. He was so gracious, and we very much appreciate him. Although he's from Santa Maria, I think it is, California, right? Santa Barbara, California. He moved to Wisconsin, graduated from Carroll University, went on to Regent University, now lives here in Wisconsin, obviously, with his wife, Italian wife, so we expect him to use his hands today. 5 children, and we're very excited to have him on our campus this morning. So, ladies and gentlemen, Justice Daniel Kelly.
Thank you, Steve. Thank you. Well, good morning, everyone. I won't be constrained by the podium because I've very kindly provided me with one of these. And as Steve was mentioning, the woman to whom I am married, she is Italian. And as it turns out, you can't be married to an Italian for 30 years, as I have been, without a few things rubbing off. In this case, it means that I now talk with my hands, just like the Italians. And gone are the days when the stoic Irishman would just stand there and use his words and would not move. And now I just feel like I can't talk anymore unless I can use my hands. And so I'm grateful for this. But I'm especially grateful for the opportunity to be with all of you this morning. I can't tell you what a blessing it is to be in this setting, in this place, to talk about these kinds of issues. Now, 3 years ago now, when I was appointed by Governor Walker to the Supreme Court, I started a conversation with the people of Wisconsin about the kind of person that they want serving them on their Supreme Court. And everywhere I've gone, and with whomever I've spoken, I hear the same 2 consistent themes. And the first one is this: they want someone who's going to be faithful to the Constitution. Now, the Constitution as it's written, right? Not as we might wish it to be, but as it is actually created and maintained by the people of Wisconsin. That's the first thing. The second one I think that you all will resonate with. They want someone who understands the difference between bosses and servants. And they want someone who understands that I'm not the boss, right? They want to understand that I know that I am there for the sole purpose of serving them. Now, these 2 themes I have found have been really well crystallized in 2 questions that I've received over the last couple of years. And I'd like to share with you those questions and how they really describe the function of the Supreme Court, and I think some of the necessary characteristics of those who would serve in that capacity. So the first question I got was a couple of years ago, there's a program that we do at the Supreme Court called Court with Class. It's not an especially original name. We have, students anywhere from middle school all the way up to law school. They'll come out to the Supreme Court hearing room, and as we hear an argument, they'll sit in the gallery and they'll listen to the argument. And then over lunch, one of the members of the court will come out and talk with the students a little bit about the nature and the history and the function of the court. And I've done this program many, many times, and I love doing it because I really look forward to opportunities to share with people kind of our civic heritage and the role that the government has played and the important but necessarily limited role that it has. And so this one presentation, as I was nearing the end, it became really apparent to me that one of the students had something on his mind, and he just couldn't wait for me to be done talking, which I understand. But he had something he wanted to ask. And so as soon as I was done and I asked for questions, his hand shot up in the air. And I thought, well, I got to figure out what he's thinking. And so I called on him. And before I tell you the question, I want you to have a picture in your mind of what this looked like. So there we were in the Supreme Court hearing room. Have any of you been there or seen pictures of it or anything like that? Yeah, some of you? Good. It is an astounding place. And I am so grateful to the people of Wisconsin for providing a place like that for us to work. But it is beautiful. There is marble everywhere. The walls are marble completely. There are these enormous murals that go around the Supreme Court hearing room, and they depict some of the most important points in the development of this concept called the rule of law. And then there's the bench of the rich, dark wood that we sit behind when we hear cases. And the entire place is designed to impress, right? Because this is where we talk about the rule of law. It's something that you can't touch, you can't feel, see. But there's a necessity to make sure that people understand when they come into that room, they are in the presence of the rule of law. And so it's beautiful. And there I am, we just heard arguments, so I'm dressed in my black robe, and I'm looking about as intimidating as I can possibly look. And in the midst of that, the student stands up, and he looks me dead in the eye, and he says, "Who's your boss?" Wow, that was a bold question from a student in that kind of a setting. But as I thought about it for just a moment, I realized, this is a perfect framework within which to understand the proper relationship between the people of Wisconsin and the governments that they create and maintain. And so I asked him, "What are your parents' names?" And he told me. I said, "Well, they're my boss." And I looked at the rest of the students in the hearing room and I said, "And your parents are my bosses too." And I looked back to the student that asked me the question, and I said, "How old are you?" And he says, "I'm 13. That's a heck of a question from a 13-year-old. So you know what? 5 years from now, you'll be my boss too. And that's the truth of it, right? So the authority that I exercise as a member of the Wisconsin Supreme Court does not belong to me. This is a borrowed authority. So when I come to chambers in the morning, I don't bring any authority with me to do the responsibilities that I have because the authority does not belong to me. And when I reach chambers, I don't find it there either because the authority does not belong to the office. It belongs in one place and one place only. And that's with the people of Wisconsin. All of it. It's all theirs. And they don't give it away. They don't sell it. They don't alienate it. They don't do anything to divorce it from themselves. What they do is they lend it to us to use on their behalf. It's a loan. And truly, as with all other loans, or most other loans at least, you write out the terms of the loan, right? Because you want to make sure that nobody forgets who's responsible for what and what you're supposed to do with that loaned authority. And so we wrote out all of the terms of the loan that the people of Wisconsin have made to those who serve in state government. And when we got done writing that document, what did we call it? We called it a constitution. And so every time I look at the Constitution, which I do all the time, that's a large part of my job, I understand two things. One, I understand that the authority that I am using is on loan to me. It is not mine, it is yours. And the second thing it tells me is that there are limitations on that authority. I don't get to do just whatever I want. There are limitations. And that brings me to the second question that I have been asked that really crystallizes this in my mind. And that question came just a few months ago. I was doing a presentation in Milwaukee over lunch, And it was a diverse group of people, all the way from liberal to conservative. There were lawyers, there were real people. And at the end of the presentation, I got a question from one of the lawyers in the room. Now, because it was a lawyer, the question had a very, very long wind-up to before you get to it, because that's what lawyers do. The 13-year-old student got out the greatest question ever in 4 words. The lawyer took a little bit longer. So I got done, and she says, Justice Kelly, I understand that you're going around the state of Wisconsin talking about how important it is not to legislate from the bench, how important it is not to make policy decisions when you decide cases. I understand you've been saying all this, but she said, I implore you, and she used those words, I implore you to reconsider your position. And I thought, well, I wonder what's coming after this. She says, you know, Justice Kelly, I understand that you were appointed by a Republican, but there was another Republican president who had appointed someone to the United States Supreme Court. And that appointee, and I won't say who it was, that appointee, well, he understood the importance of making policy decisions. Because he understood that sometimes when a litigant comes to you, you are the last stop for that person to get the law to be what they need it to be. Because sometimes it is too hard to get the law changed through the legislature, she said. And she said sometimes it takes too long to get the law changed through the legislature. Yes. That's not a foul call or anything like that. I would have thrown a foul on that question. And she said, and so sometimes when the litigants come to you, you are the last chance they have to get the law to be what it needs to be for them. And so I implore you, please reconsider your position. Please consider making policy decisions when you decide cases, if that's what the litigants need. And I thought, wow. And I didn't say this out loud, but I was thinking, that is probably the most brazen request I have ever heard, to walk across the Capitol building, steal the legislature's authority, bring it back to the judiciary, and exercise it there. I've never heard it put quite that brazenly. But I appreciated the question because it is a good distillation of what some jurists think about their role. Some jurists do believe that it is their function to make policy decisions, to make laws, to decide which laws are wise, which laws are prudential, and which are not, and which are worthy of being enforced and which are not. But out loud, I said, well, I understand the expediency argument, because basically that's what it was, right? It's just easier to do it this way. It's quicker to do it this way. And after all, don't we have judges there to make sure that the right thing happens? I get that argument. So there are a couple of things that we should probably crank into the calculus to determine whether this is a legitimate thing for a court to do. And so I told her, the first one is a question of self-governance. Right? Over 240 years ago, we looked at the most powerful empire known to the world, and we bid them adieu because we decided that it was imperative that we engage in self-governance. We had no need of a king to govern us for ourselves. We wanted to engage in self-governance. And that means that we choose our legislators, we choose our representatives, and they go and they make the laws, and we will be governed by the law and not by an individual. And we fought a long and bloody war to make sure that we had that liberty, that we had the ability to engage in self-governance. But what happens when a jurist decides that he will make a policy decision? as he decides a case. He will decide which laws are worthy of enforcement and which are not. He will decide which laws need to exist if they don't already exist. What happens when that happens? Well, what happens is the realm of self-governance available to you shrinks. Because every single time that a jurist answers a policy question, he withdraws that question from the realm of self-governance. No longer can you go to your legislators and say, I need this question to be answered differently. I need a law that addresses this question in this particular way. You don't get to do that anymore if a court decides it for you. Because when we decide questions, we don't just say, I think this is a good idea, and so we'll do it. If you watch the United States Supreme Court opinions and you read them carefully, every time that they purport to make a law, when they decide a policy decision, they will refer it to the Constitution. They'll say, the Constitution made me do this. And they'll always look for a really amorphous part of it so they can pack it in there so there's nothing that would specifically contradict them. But there's nothing in the Constitution actually requires the decision that they made. But having referred it to the Constitution, it places it off limits to you. It places off limits to your legislators. They don't get to address that question anymore. And so as jurists do this, time after time after time after time, the area of self-governance available to you shrinks and shrinks and shrinks. And so what happens when a jurist makes a policy decision, when a jurist decides what the law ought to be rather than what it is, it erodes the very purpose for this experiment that we started. It erodes your ability to engage in self-governance, that thing that was so precious that we decided to go up against the most powerful empire in the world to make sure that we could have it for ourselves. It takes it away. And so the thing that we fought for with blood and steel, jurists steal away from you by their soothing words as they make decisions so that the litigants in front of them can get the law that the jurist believes it needs to be, rather than what you believe it needs to be. And so I told her that is those two things, but that matter of self-governance leads me then into the second consideration in determining whether this is a legitimate thing for a jurist to do. And that's a question of authority. I said, where would I get the authority to do this? Who says I get to make policy decisions? Who says that I get to decide which laws should be enforced? Who says? Where do I get that authority from? I said, I understand that all of the authority that I exercise, all of it, is lent to me by the people of Wisconsin through the Constitution. And therefore, if I have the authority to do what you've asked me to do, I must find warrant for that somewhere in the Constitution. I said, so let's take a look at what the Constitution says about the power to make law. I said, well, I go to the part of the Constitution that talks about the legislature, because there I find it says that all the legislative authority is vested in the legislature. All legislative authority is vested in the legislature, not some, all of it. Okay, fine. Well, if it says all, maybe if I go down to the fine print in the constitutional provisions, maybe I'll find something that says, yes, all legislative authority is vested in the legislature, except for when Dan Kelly thinks it's really important to make a law. And of course, there's nothing like that there. I said, so I looked at the part of the Constitution to see what it says about the authority that I'm supposed to exercise, and I find there that the Constitution says that the judicial power is vested in the judiciary. Well, the judicial power is nothing mysterious. It's simply the power to apply the law to the case in front of us, resolve it, render our judgment, and call it a good day's work. That's the judicial power. I thought, well, maybe there's an addendum or a codicil or something down there in the fine print that says, in addition to the judicial power, the judiciary shall be empowered to make laws when it thinks it's really important to do so. And of course, there's nothing like that there either. And so I told her, I appreciate your question, but I'll have to decline your invitation because I don't see that the people of Wisconsin have lent me the authority to do what you've asked. You know what she said in response to that? She said nothing, because there is no response to that. That authority that belongs to the people of Wisconsin, it is the entirety of the authority available to create and maintain governments. And if I don't receive it from you, I don't receive it from anywhere. And that's the end of the story. Now, the thing that amazes me is this is not a new question that she asked. It's not something that has become a concern just recently in modern times. This is a question that is as old as our country. So when the founders were putting together the Constitution, they wrote a lot about why they were constructing it the way that they did. And they had a fair amount to say about the judiciary, right? And so I read back and I looked at the contemporaneous documents and I read what Alexander Hamilton had to say about the judiciary. You guys know Hamilton, right? Broadway star, rapper extraordinaire, that guy. I've taken the liberty of translating some of the original rap into English so that it's accessible to all of you. So I read Alexander Hamilton, and he says, in describing the judiciary, he says, the judiciary is the least dangerous branch. It's an interesting choice of words. Why speak of danger when speaking of a branch of government? Well, the reason they did is because they understood that the greatest threat to liberty is a government run amok. So they wanted to make sure that there were enough limitations on the government that they were forming that they would not intrude on your liberties. So they said that Hamilton said that the judiciary is the least dangerous branch because it had neither force nor will, but merely judgment. Right? Force, he's referring to the executive branch. Right? They're the ones that actually enforce the law. They have force. Will, that belongs to the legislature. The will to make a new law to represent your interests. So what's left? Judgment. Judgment. That's all the court has. And in fact, the work that we do results in probably the most humble document a government could possibly create. When we decide a case, once we're done, we go and we write all of the reasons for why we decided the case the way that we did. And we explain the laws, and we explain the logic and the rationale that led us to the conclusion. And that document, we call that an opinion. An opinion. It's our opinion of the law. It's not a mandate. It's not an edict. It's not a statute. It's an opinion. This is what we think the law requires. And what happens with that opinion? Does it go into effect? Does it immediately require parties to do anything? Well, the founders understood that the judiciary's opinions are entirely dependent on other branches of government to carry it into effect. We need the executive to look at our opinion and say, yes, okay, we will put that into effect now. All we do is we render an opinion. That's it. So as we look at this power that the judiciary exercises, it exists in a very narrow and a limited sense. Now, Hamilton wasn't done describing the judiciary. After he said that it's the least dangerous branch, he said, however, the people will have everything to fear from the judiciary if the judiciary should combine its power with that of the executive or the legislature. Everything to fear. We go from 0 to 60 in a heartbeat. The least dangerous branch to you have everything to fear if we take over the executive or the legislative power. And this is what the attorney was asking me to do. She was asking me to combine the power of the judiciary to that of the legislature. You, judiciary, she was saying, you should make the law. You should decide what policy shall be. You decide which laws are worthy of enforcement. But that's the legislative power. And so if I were to do that, if I were to do as she asked, to walk across the building in the Capitol and steal the legislature's authority and bring it back to the judiciary, I would be party to making the judiciary something that the people of Wisconsin should fear as dangerous. So I politely declined her invitation to reconsider my opinion and my position on that question. Now, there is a very deep divide in schools of thought about what the role of the judiciary is, and some of my colleagues subscribe to a different idea. They believe that it is within their power to change the Constitution. And as I've watched the United States Supreme Court over the many years that I've been in practice, I've seen jurists come to the bench promising that they would do nothing but apply the law as it exists. They would call balls and strikes, and that would be the end of their authority. And then as I watch, they start making policy decisions, and they decide what laws are prudent and wise, rather than deciding what they require. And I wonder why. And I think I've figured out a little bit of why. The Supreme Court of the United States and the Supreme Court of the state of Wisconsin are courts of limited jurisdiction. We have discretionary jurisdiction. We don't hear every single case that people want to bring to us. We don't have the capacity for it. We get approximately 900 requests a year to hear cases. We can only hear about 60 of those a year. And so we have to decide which to take. And the way we do that, it kind of makes life difficult for us because we take nothing but the hardest cases. And so every day that I walk into chambers, there's a stack of cases on my desk, and they are nothing but the hardest cases in the state of Wisconsin. And the same is true of the United States Supreme Court. When they walk into their chambers, they look at nothing but the hardest cases in the country. Sometimes, you might not like the results of what the law requires. In fact, I'm reminded of something that Justice Scalia said several years ago at a presentation I was at. He said, if you're a jurist and every opinion you write, you like the conclusion and agree with the conclusion that you come to, you're doing it wrong. Because the chance that you agree with every law that's on the books, the chance that you will like the result that the law requires in every single case that you come across, the chances that you will like that every single time are zero. So if every opinion you write comes to a conclusion that you like, that's an indication that you're importing your personal preferences into the process, that you've abandoned the project of applying the law and you have become one who would make policy decisions while you decide cases. And so when Justice Scalia said that, I realized, yeah, that's the key, I think, to understanding why some jurists slide over time. Because when you come in and you are deciding hard cases and they come to results that you don't personally like, some days it's hard to do that. And perhaps one day a jurist comes in and says, today it's not going to be like that. Today, when I decide this case, I'm going to like the result because I just think it needs to be this way. And I'm tired of writing opinions in which I don't like the result. And so this one time, just this once, I will write this in a way that I like the result. And so they do. And they walk out of chambers and they feel good. I like that result. Oh, I feel better. I feel vindicated. I think that's what should happen. And they come back the next day and still they have nothing but the hardest cases in the country sitting on their desk. And having done it once, it becomes easier to do it twice. Okay, this one too. I'll make sure this one comes out in the way that I think it should come out. And so they do it again. And every single time you do that, it becomes easier and easier and easier to abandon the application of the law and instead bring in your personal preferences and call it justice. But that's not justice, my friends. Justice is applying the law as it exists, as you have asked it to be. Applying that law to resolve a case and render our judgment and our opinion. And it takes, I think, some steel in the spine to make sure that that's where you stay. So where does that come from? How do you know that a person will stay at that place, that they won't move over time into a place where they start making the law instead of applying the law? Well, I'm reminded of the second thing that people in Wisconsin tell me that they want. They want someone who knows the difference between bosses and servants, and that we're not the bosses. There was a church service I was at just shortly before Christmas last year. My wife knew the pastor's wife. This wasn't our regular church, but they invited us out to be a part of a service where they invited several other state office holders to be. And we were pleased to go. And it was a lovely service. And afterwards, we were in the lobby talking with some folks, and the pastor came over to greet us. And he was just the most gracious man. He was wonderful. He walks up to me and he says, "Justice Kelly, I want to thank you for being here in our service today. It's wonderful to have someone so important participate in our service." And I thought, oh. I said, "Pastor, let's just rewind that for a moment." I said, "I've often thought that where you rank is inversely proportional to the number of bosses that you have. The more bosses you have, the lower your rank. Fewer bosses you have, higher your rank, right?" It's just, that makes sense. I said, "Pastor, how many bosses do you have?" Well, you can imagine what he said. He said, "I got one." I said, "Yeah? I got 6 million. So between you and me, Pastor, you outrank me by a whole heck of a lot." And that's the truth of the matter. I have 6 million bosses, 6 million of our fellow Wisconsinites to whom I am answerable and to whom I am responsible. I am exercising their authority, and they have every right and responsibility and duty to come to me and hold me to account in the way that I exercise that authority. And so when I put on that black robe, and I look stunning in it, I can assure you, when I put on that black robe, any room I walk into, I rank the lowest of anyone there. And I don't care who else is there, I rank the lowest because I am answerable to every single Wisconsinite in this beautiful state of ours. I rank the lowest. And if you have it firmly fixed in your mind that you are a servant, and what are servants to do? They are to do their job with a good and cheerful heart. And that's all. If you have it firmly in your mind that you are a servant and that you are exercising your master's authority for his benefit, that will keep you where you belong. That will keep you from wandering off and thinking that you own the authority, thinking that you have the right to make laws, that you have the right to decide what is just, separate and apart from what you have demanded the law to be. And so that's what I've been doing the last 3 years, doing my level best to serve the 6 million bosses that I have, with fear and trembling, but with an incredible amount of joy. Because as it turns out, you guys are phenomenal bosses. I love working for you. This has been the honor of a lifetime to serve on your Supreme Court as one of your servants. And it's been an honor to come here this morning and share these thoughts with you. And I thank you so much for your attention. May God bless you in everything that you do this day. Thank you. So now,
Will you take some questions?
I would love to. I'm here to be quizzed. Yes, sir.
Hang on, Del.
Curious to hear who your mentors are.
Yeah.
I'm curious to hear who your mentors are.
So I have several, and many of them don't even know that they were my mentors. So I'm fond of saying that I've never had an original thought in my life. And I think that's largely true. You pick up things from other people, you put them together, you figure things out. But all of the great thoughts come to me down through the ages. I'm an inveterate bookworm. I love reading. So I read deeply in our history. When I became interested in the law, I read deeply in the law even before I came to law school because I loved it. So I would say that that two of my greatest mentors, and they would never know this. Justice Scalia probably does now, but he would be one of my mentors. I have read his opinions ever since he came to the court, and I have been instructed by what he has done in the way that he comported himself on the bench, because I think that he is a fine example of someone who thoroughly understands that he is a man under authority, and that his responsibility is to exercise the authority that has been lent to him in a faithful way to those who have lent it to him. In everything that he does, in the arguments that he conducts, in the opinions that he writes, he understands that important but narrow role that he has. And so when he writes an opinion, and I try to emulate this when I write my opinions, he starts with the law that's applicable to the case, and then he exercises rigorous logic as he works from those premises to the conclusion. And I think he understands, as I do, that if you have an unbroken chain of logic from beginning to end, that will assure you that you have applied the law and not your personal preferences. Because as it turns out, logic doesn't care about what your preferences are, right? So if you start with solid premises and you use solid logic to get to your conclusion, you can be assured that the result is what the law requires. And I've learned this from Justice Scalia. From Justice Thomas, I've learned a love of the historical aspects of the law. If you read his opinions, you will find that invariably he will go back 200, 300, 400, 500 or more years to find the wisdom of the ages in deciding the questions that he must decide. Not that he's making the law as he goes along, but he understands that we stand on the shoulders of giants, and that the law has a patrimony that goes back century after century after century, and he goes back and he finds the principles so he can understand accurately why the law is as it is and what it requires. And he brings all that to bear on the opinions that he writes. And so his opinions are rich with history and rich with context. And if you have and if you should be interested in the law and where it comes from, read Justice Thomas's opinions. They are a wonderful education. So those I would count those as primary amongst my mentors. Yes, sir.
First of all, I appreciate your judicial philosophy, but as just a challenge, to what degree is original intent malleable?
Yeah.
You only have 5 minutes. Sorry.
Yeah. Okay. So there are several law review articles that are resident in that question. What I will say is this: so there are a number of terms that have been developed over time to describe what a constitutionally faithful jurist does, what the reasoning process is. One of those has been original intent. Justice Scalia kind of shied away from that description. He would refer to himself as a textualist. And what he looks for and what I look for when we're looking at the Constitution and statutes, we're looking for the original public meaning of the words that were used, right? Rather than the intent. The intent is it's very malleable. And the intent that goes into the making of a law or a constitutional provision is inscrutable quite often, right? I mean, people have all kinds of intents for the things that they do. And in fact, I mean, this is something that comes up in the interpretation and application of statutes. What was the legislative intent behind this statute? And my invariable response to the question, and forgive my bluntness, is I don't care. Because it's not the intent that gets enacted. It's the words of the statute, right? And when we're talking about the Constitution, it wasn't the intent of the framers that got enacted. It was the words that they chose. And so our responsibility is not to figure out what was resident in their minds as they were drafting this. Our responsibility is to figure out what was the original public meaning of those words that they used, and the phrases and the concepts. Because that's what they were doing. They were creating a structure in a specific context, in words that people of that time would understand, in concepts that they would understand. And that's our responsibility, is to figure out that original public meaning. And that, as it turns out, is a lot less malleable than the intent. And that's what we're looking for, is as jurists who seek to be faithful to the Constitution and faithful to the statutes that the legislatures enact, what we're trying to do is figure out, what did this mean? Not what the legislators themselves intended. And I've written actually about this in a couple of opinions that I've offered. Because when we look at legislative intent, we can go back and similar in constitutional history, we can find remnants of what different people were thinking, right? And in the legislature, we can find notes, we can find drafting notes, we can find Legislative Reference Bureau, what they thought about this or that law. We can find all that, but ultimately what it comes down to is you're finding out what a very few people intended with respect to that law. So you might find maybe legislator A, he says, okay, here's the draft, but then he writes some notes along with it, sticks it in the legislative enactment file. And he says, this is what I was thinking, and this is the reason I wanted to have this. Okay, fine. Now, the court comes along and they say, what was the intent of the legislature? And so they go back to those notes, and they pull that out and they say, well, here's legislator A, and he was the sponsor of the bill, and here's what he was thinking, and here's what he wanted this to accomplish. Okay, so now you know what that one legislator thought. Well, we got 99 assemblymen and 33 senators. What about the rest of them? What were they thinking? You know, maybe they were thinking this would accomplish an entirely different thing. Maybe they had entirely different rationale for wanting this. Maybe they were going to vote for this because they thought that person would vote for their thing. Maybe they had no intent at all. We don't know, right? So if we go back and we try to figure out what was in the enactors' minds, what we're doing is using that really, truly as a vessel to incorporate what we want it to mean. Because there's no chance in the world that we'll be able to figure out what a majority of the legislators or a majority of the founders were intending with respect to any given provision. So I tend to stay away from questions of intent precisely because they are so malleable. And so whether I'm looking at a constitution or a statutory provision, I want to know what the original public meaning of those terms were. Good? All right, what else do you have? Yes, sir.
I could probably be heard without the microphone, but what you described on the judicial side is what we teach and practice on the hermeneutical side of Bible interpretation, textualism. And, some of the same principles are applied. What was the original intent? Well, we won't use that either. What does the text say? What do the words mean? And it doesn't matter how many commentators over the years have commented what they think about the passage. What is important is what did the author say, and that's God through the writer. Now, having said that, I'm one of those attorneys that's getting around to the question. All right? What you brought up earlier, why do people change? You have judicial review. We have people that forsake very obvious principles of Scripture, and they have reasons for that, they think, that are good. They think we have a living document like the Constitution, Wilson, a living document, and they change. But they started out right. How did that happen? And I want to know if you agree with this assessment or not, but I've seen some very good people in ministry that, because of a false compassion and to please and to make people feel that they feel for them, they move instead of sticking with the text. Do you find that among your colleagues, historically and otherwise? Is that relevant in your case as well?
It is. Thank you for the question. And I think you're right. I mean, we're trying to do the same thing. We're trying to figure out what is the meaning of the document, right? And so we're going to, so we'll use the same kinds of tools. But as far as the movement, I think that's similar as well. So I don't think that my colleagues who would subscribe to a more living constitutionalist philosophy, they're not doing it out of ill will. They are doing what they see as the right thing according to their best lights, right? They are compassionate. They want people to have a just result. They want to do the right thing, and so I would never fault them along those vectors, right? I think they come to this with the most honorable of intentions, but without an understanding of the limitations on their role. So if I had no understanding of the limitation on my role, I'd probably be doing the same thing they did, right? They are empathetic. They reach out to those litigants and they see the difficulties that they're in. And sometimes the law does have a harsh result. And so the question, and that's where the hard questions come from, right? So what do you do when the law commands a harsh result? Do you say, no, I will place myself above the law and decide for myself what an appropriate resolution would be? Or do you say, I am a servant of the law, I am a man under authority, and I don't have any authority to go beyond what the law requires? And that's my answer. In the pastoral context, I can imagine, and this is speaking obviously entirely from the outside, but I can imagine that a similar dynamic goes along. If the Bible commands a particular result and you look at it and you say, but that's harsh and that's hard, and I can see where this individual is going to suffer because of that requirement, I think it's really easy to start thinking, well, maybe, God is a compassionate God. God is a God of love. And how could he intend this result? And so I will go back, I'll go upstream in reasoning, and I will reconfigure these difficult scriptural passages. And I will make it say something that is more conformable to what I would have it say, and what I think is just, and what I think is kind and compassionate. But that is to put yourself above the text, right? And I think that's especially problematic in the pastoral realm, because the text that we have, we understand to be God's word to us. And if you presume to put yourself above that text, I don't know where you end up. I don't know what you would be doing after that point if you're not bound by what God has informed us. And so I think the dynamics are similar, right? A pastor must understand himself to be a man under authority, and that he cannot exceed that authority or ignore it or place himself greater than that authority. And it's good. Yes?
So when you were talking about picking the laws or picking the cases that you'll be judging on at the Supreme Court level, where do you bring in your personal opinion over which cases should come before the court, and keeping your distance from your personal opinion being brought into those cases being chosen? How do you wrestle with that? Yeah,
so that's a good question. When we're deciding cases, which cases we're going to hear, we're not applying any law to that, right? So this is prior to us getting to the merits of the case, and what we're looking at is what's creating problems in the community as far as a proper understanding of what the law requires. So sometimes we get constitutional questions that have never been asked before, and so we look at those and, well, we need to take that case because eventually that question will come up again, and we have to make sure that there's an understanding of how that constitutional provision applies, and because that's going to control everything that all of the courts do. Sometimes we have 4 district court of appeals we have a unitary court of appeals, but they sit in 4 districts. And sometimes they come up with opinions that are in conflict with each other. One district looks at the statute and says it comes out this way. Another one says it comes out the other way. Excuse me. And so we take those cases to resolve those kinds of disputes. Sometimes there are questions of common law that we need to apply in new circumstances. So, just as an example, search and seizure law. This is something that is as old as the English common law, and yet it will need to be applied to new circumstances from time to time. So, for example, the advent of cell phones and the wealth of personal data that is contained on it, and the password protection that prevents anyone else from accessing that data. And so the questions, just surprisingly, fairly recently, came up. Well, what can police do when they have legitimately stopped a suspect and they're searching them and they come across a cell phone? Can they look at all the contents of the cell phone? Well, the common law of search and seizure, that was the first time that all of those principles have been brought to bear on a question like that. And so those are the kinds of questions that we need to address. And we go back and, in that kind of a circumstance, we go back to the original purposes and principles behind search and seizure, and then we figure out, how does that apply to something like a smartphone that contains virtually, these days, gives you access to the most personal and confidential aspects of a person's life. How does that apply in that circumstance? And so those are the kinds of considerations that we go through in deciding which cases that we're going to take. So we don't decide the merits of the cases at that point. It's just which of these cases present a question that really only we can resolve, and then we'll take those up.
All right, it's 8:30. One last question.
Justice Kelly, thank you for sharing your philosophy of the court. I'm wondering, do you see a difference between being a conservative or liberal politically or legislatively versus in the jurist area?
Yep.
In other words, could a liberal jurist be conservative in his views of the court? And why do we use those terms to describe jurists if they all should be interpreting the Constitution with the kind of philosophy you just espoused?
Yeah, that's a great question. And the reason we use the same terms is a failure of imagination, I think. So it is problematic because it brings to mind the wrong paradigms within which to assess a judicial philosophy. So when we talk about conservative versus liberal jurists, we're talking about something fundamentally different from someone who is conservative versus liberal in public policy, right? So a liberal politician, someone who has liberal beliefs with respect to policy, can be what we would call a conservative jurist, because they are equally capable of setting aside their personal beliefs about what policy ought to be and simply applying the law as it exists. So the terms conservative and liberal, the entire meaning of those terms change as we go from the legislative to the judicial context. And that's why I generally try to stay away from using that terminology because what my personal political beliefs are completely irrelevant to the job that I do on the court. So I try to use terms like being a constitutionalist jurist, or someone who's going to pursue constitutional fidelity, right? Because that, I think, uses some terms in a paradigm that really gets to the point of what the jurist is supposed to be doing. We are to pursue the law as it exists. We are to be faithful to the Constitution as it exists. And we set aside questions of policy, whether conservative or liberal, and we reserve those to the legislature where they belong. And there they can have their full-throated conversation about what our policy ought to be. But then when they finish the conversation, when they enact a law, that ends the partisan nature of the conversation. That comes over to us, and we simply apply that law without any consideration of its partisan origins. All right? Good. Well, thank you all. It has been an absolute delight to be with you this morning. Thank you for an opportunity to spend this time here this morning. Thanks.
All right, that's it for this morning. Justice Kelly is going to speak in an assembly, and I think they'd be welcome to come join us if you'd like to at 9:15 at the building next door. Otherwise, don't rush off. You're welcome to stay around, have a cup of coffee, enjoy the fellowship, and we'll see you again soon, all right? Have a great day.